Pinterest Copyright Infringement by Jonathan Mauldin and Tory Foster. Business Law 2150, Section 109. Appalachian State University. Pinterest is an online platform that allows users to eponymously share and repin photos of various subjects. These primarily focus around life hacking, various crafting and domestic activities such as recipes and DIY projects, and quotations and common sayings. Most users access Pinterest as a method of gaining new ideas and/or window shopping for their future projects. Though this law is true, Pinterest users rarely complete even a small percentage, if any, of their repinned ideas, resulting in Pinterest commonly being a method of occupying time rather than inspiration. Pinterest is a Fortune 500 company that has grown globally over the past few years. As of July 2013, 70 million people use Pinterest, which represents 1% of the world population, or 2.5% of the population with access to internet. With Pinterest affecting this number of users, any potential legal issues could have a devastating impact. A major potential issue is copyright infringement. A quick Google search on how to use Pinterest without breaking the law comes up with over 78 million results. Now, not all of these involve the same legal issues. However, the majority surface around copyright infringement concerns. Most Pinterest members are conscientious about giving credit and a link back to their source, says Greek geek author Ellen. In general, users do believe that they are fulfilling their duty to give credit under copyright law. Unfortunately, this is not the case. Copyright law is seemingly upheld by the general public when credit is given to the original creditor. However, copyright law requires credit given in addition to permission to use the material from the original creditor. While Pinterest sometimes gives credit, permission is not required to repin an item. Both the lack of credit given and lack of permission can be issues. The lack of permission is not always an issue, as most original authors appreciate the extra advertisement. However, sometimes the additional publicity does more harm than good.
According to Connie Mabelson's article addressing the online laws associated with Pinterest and user-generated content and the Digital Millennium Copyright Act, the copyright arises at the moment when the author fixes the work in a perceivable format for the first time. A work that is original and fixed in tangible form is automatically protected from the moment of its fixation and is given a term enduring for the author's life plus an additional 70 years after the author's death. The DMCA, Digital Millennium Copyright Act, was signed into law in 1998, amending the Copyright Act Title VII in order to provide new limitations and establish liability for online service providers, or OSPs, concerning copyright infringement. One of the new limitations outlined in the DMCA is the use of UGC, or user-generated content. When user-generated content is used without the permission of the original author, it is a violation of the DMCA. Before the Netcom case, individuals argued to hold ISPs, or Internet Service Providers, responsible for Internet copyright issues. The Netcom case established that it is unreasonable to hold ISPs accountable when they have only set up the system necessary for general Internet usage, because there is no guaranteed way to deter the copyright infringement from happening. This also helped develop immunity under Storage Safe Harbor for ISPs, which removes liability from ISPs. This also places the potential liability between sites such as Pinterest and the user. Here are some suggestions by experts of legal changes to make this current issue less of a liability in the future. One idea is to have a credit stream available on all pins. Another is for Pinterest to ask permission from the original pinner if they want their pin to be available to be repinned or not at the time of their original pinning. The last major idea is a non-commercial exception to copyright infringement. as Diane Zimmerman suggested, but it would further complicate piracy laws. For example, those who use original information without permission or credit from the author would not be violating copyright laws if they did not use it for commercial purposes. In conclusion, Pinterest, a very popular social media site, has been under criticism for the potential of copyright infringement. Most users are unaware that they may be violating copyright law by repinning on this site. This is due to a lack of credit to and a lack of permission from the original author of the pin. The violations committed are outlined under the DMCA and pertain to UGC law. Through the Netcom case of 1995, the liability has been placed between the site and the user. So users of Pinterest are now at risk of committing copyright infringement when simply repinning a craft idea. There are multiple solutions from experts on how to solve this problem, but it may take time and the consideration of other statutory decisions to reach a liability-free social media situation. Thank you for your time, and here are our references.